Welcome everyone. This is your host Prabal Gupta and you are listening to the Capital Analyst. Today is the first episode of a new segment, Book Discussions with Authors, and our guest today is Mr. Eashan Ghosh. Eashan Ghosh is a New Delhi-based lawyer and consultant specializing in intellectual property law. He started his career at Fidus Law Chambers and worked for a couple of years at S. Majumdar and Company before starting his own practice. He's not one, not two, but 6 times gold medalist from National Law School of Indiana University, Bangalore, and has a distinction honors from University of Oxford. He has argued cases before the Supreme Court of India, various high courts, and the Intellectual Property Appellate Board. He has taught students at NLU Delhi and his alma mater in Bangalore. Today we are going to talk to him about his new book, Imperfect Recollections, this Indian Supreme Court on Trademark Law, that came out in 2020. Tune in to listen to this insightful conversation. Welcome to the show, Eashan. How are you doing?
Hi, all well. Thanks for having me on, Prabal.
Sure. So let's start with the first question. What drove this interest in law, and especially in law, when did you decide that intellectual property or trademark law is something that I want to make my specialization in?
So I guess like all kids of my generation, we were forced into making decisions far earlier than we were ready to make them. And in my case in particular, I think I was one of those people who wanted order and clarity and structure in life from a very young age. Some of it was obviously inherited in the sense that my parents are both like this, and my extended family is very much like this as well. But the other part of it was perhaps slightly more forced by circumstance, in the sense that I was fairly clear quite early on in life that I didn't want to pursue science at a higher level. And this became a slight problem in the household because both my parents have a science background and my extended family. I think you have to go very, very far and deep into my extended family to find somebody who hasn't studied science. And therefore, it became a point of contention quite early, at least in my own thinking, perhaps as early as the ages of 14 or 15, that I needed to be very clear about what I wanted to do if it wasn't to be science, because I knew that that was going to be the default option. And so what happened is that, at least at the first stage, I was able to identify maybe a couple of paths based out of my own interests at the time. And again, my career now is a product of interest that I had that I had while I was a teenager, which is actually quite strange because a lot of people tend to move around careers and things of that nature. But with me, this was literally never the case. From the age of pretty much 15 or 16, I was very clear that I wanted to get involved in some form or capacity in either in media or in sport. And given that I didn't have a particularly big talent on the media side of things, and I didn't have a particularly big sporting talent, it became basically a straight choice between either writing about those subjects or sort of becoming somebody who could interact with those subjects on a daily basis, and sort of enter the legal option, right, immediately. And in fact, if you go back, I don't know if I'm able to dig this up for you, but we used to have to do these little things in high school for the school yearbooks, where we'd have to project our lives like 10 years into the future, 15 years into the future. What do you think you're going to be? And I think if somebody could dig that out from whatever year I graduated, I think you'll find a very clear line to say that Eashan is interested in media and intellectual property, and he hopes to become a lawyer. So the media part, perhaps I've left unattended, but the intellectual property part has sort of flown pretty directly. So that's the broad story of how I got involved, and I say this quite often to people, and I mean it completely seriously, is that if I wasn't an intellectual property lawyer, there's a very good chance I wouldn't be a lawyer at all. I'd probably be doing something else. So to me, that choice between, okay, now you're a lawyer, now what area of law you specialize in, was never an actual conversation, because I knew that I wanted to use intellectual property as the platform, and then law just happened to be one angle to it, and that's sort of how I got involved.
Okay, so let's come to the book now. So when did the idea of writing a book in general first came to you, and how did you decide that this is something that I want to write about, documenting the main Supreme Court cases relating to trademark law and how they have shaped the evolution of this law in the country? How did you go about it? Did you set a specific timeline? If you can walk us through what was going in your mind.
Sure. So the difficulties that came up in the process were entirely unexpected and rather difficult to deal with, and we'll get to those in turn. But it's useful to sort of think back to that process now for me because it was very clearly divided into two separate phases. And the first of those phases I write about in the preface to the book as well, if you've had a chance to have a look at it, is that it began out of a breakfast conversation with my father. This happened on a Sunday in May. I remember the day very clearly. This is at a time when I'd been teaching a seminar course at the National Law University in Delhi for, I believe, a couple of years at that point, and I was maybe 4 or 5 years into my career. Actually, probably closer to 4 years into my career. And I was just spitballing ideas about what I could do with all the notes that I had collected in attempting to teach these courses. And my father just gave me the idea that why don't you just write something around it? You don't know what it's going to turn into necessarily, but it could turn into either a series of articles or it could turn into something that you want to do more with. And then as the conversation proceeded, he just said, is there any Supreme Court law in what you teach? And I suggested, yes, there is, but it's rather disorganized and we don't really know sort of how it fits in, etc. And he says, why don't you do that? Why don't you try and put it in order and sort of attempt to have it make sense? And that struck me as being a very, very ambitious thing for one person to try and do, is that sort of take this broad view, like you're standing on top of a hill and you're looking down at all the Supreme Court case law that exists. And I sort of dismissed the idea out of hand at the time. And I was like, okay, listen, you need to calm down. This is not something that one person can do. And the conversation just drifted off into other channels as it often does over breakfast. But then the next day, and it was a Monday, I remember it very clearly, we had the conversation on the Sunday over breakfast. And then on the Monday, I was at work. And just subconsciously, I started engaging in this activity of trying to figure out, how many Supreme Court cases are there on Facebook. And that's sort of how the process got started. And I remember at the end of that Monday, I looked over a document. I remember the image of that document is very clear in my mind's eye. Is that it was, Verdana font, size 10. I managed to list all these Supreme Court cases. And I found at the end of the day that I had collected, I think, 76 cases it was. And I realized immediately that, wow, I'm actually really, really sort of invested in this already. And let me see what I can do with it, where I can go from it. And one of the big challenges that I had, and sort of leaving the conversation towards the challenges that I had, is that with me, as with anybody else in a sort of entering the practice of intellectual property law, or any kind of law actually, you sort of enter in medias res, so to speak, in the sense that you don't really know what came before you and you don't have a good idea of what the law will look like after. And I was quite young still at the time in the profession. I hadn't been a lawyer for very long. So this idea of somebody as young as myself gaining that giant big picture perspective on how the whole history of law, etc. has been, was actually quite a daunting thing. I didn't think I had a particularly good handle on it at the time. And at some level, I still remain a bit of a student of the game, because you have to, because you can't presume to know everything, I think, especially in an area as fast moving as I can. So anyway, that's the approach and the attitude that I took to it, is the sense that I probably don't know very much. Let me see what I can discover. And probably over maybe the 4 months or so that followed, I timed it, I think, at 138 days. I wrote the core of what eventually became Imperfect Recollections. So the chapters on jurisdiction, which we probably get to in our discussion, and the chapters on trademark similarity, which I think is the soul of that book. Those sort of first 6 chapters came out of the core of what I wrote over the next 4 months after that May. And the process that you mentioned is something that I'm very happy to share, because I look back on that process with a lot of fondness. So I was working a full-time job at the time. I was litigating at the Delhi High Court. So I would wake up at 6 o'clock in the morning, do morning things, deal with my responsibilities in the house, whatever few responsibilities I did have. 7:45 I was out of the house, and I needed to beat the traffic in order to make it to my office in South Delhi from Noida. I would take the bus. I would make it to office by about 8:30, 8:45. We'd set up for the day. I try and do a little bit of sort of organization of thoughts as far as the book was concerned, or what would eventually become the book. I didn't know it was going to be a book at the time. But my research, as I called it then, and I referred to it as the little folder on top used to say Top Secret Project, because I didn't really know what I was going to do with it at the time. And so I'd take about 15-20 minutes before everybody else came into office, just to organize my thoughts for the day and to be able to see when I would have the time to be able to discuss everything. Then I would just get back into work. So 9:30 or so, my day would begin. We would go to the court. We would do a full day in court. We would come back. We would do a full day of work. And then everybody would start to disperse from the office at around 8:15. We were done for the day. And then I would stay back after everybody left And I would sit and sort of assemble my thoughts on what I was going to do. I would do a little bit of research. I would try and, express things that I'd read into written form. And I would continue this process until about 10:15 or 10:20 at night. And it was a 5-minute walk from my office to the bus stand, because the last bus from South Delhi to Noida would leave, the 392 would leave at 10:25 p.m. So I needed to make that bus back. I would then catch that bus. I would take half an hour, 40 minutes that time at night. I would make it back by about 11:15 p.m. I would sit down with my mom, who was barely sort of half awake at the time. I would have dinner with her. I would have a conversation with her for 15 minutes. She would go to sleep, and then I would sort of set up for the rest of whatever the following day. I would try and entertain myself. I'd watch a bit of TV, whatever. I would go to sleep at 2, and then I would wake up at 6 and begin the process all over again. So I did this for 138 days is what I timed it at. I finished by about early October. Or at least the core of this work was finished by early October of that year. And then I kept adding little bits and bobs as I kept discovering more Supreme Court cases. So as with any research project, I think you underestimate the size of the project at first. So the more you get into it, the deeper the hole that you're in sort of appears to be. And I got to the point where by the following March, I was pretty much done. I think I had covered pretty much every Supreme Court case that I had to cover, but I hadn't written it in any structure. I hadn't covered, I had no sort of big picture idea of what it was supposed to look like and so on. And then for certain reasons related to my personal life and so on, I had to stop that process. And I actually had to take a bit of a break and shift things around and take a bit of a step back from work. And so what happened is that over the course of maybe the next 18 months or so, I didn't touch this thing at all. I just left it there. It was this little folder labeled Top Secret Project, and it stayed there for 18 months. And I did not, I swear to you, I did not touch it once. And then what happened is, in the summer of 2019, the opportunity that I had to step away from work sort of crystallized into step away from my existing job, sort of crystallized into more personal professional opportunities, if that is to coin expression in those terms. And so I was very clear that I wanted to leave the place where I was working, and I didn't yet know that I would want to branch out on my own. But I did think that, okay, fine, I've now got this work that I did over the course of almost maybe 10 months or so, 18 months previously. So I need to now figure out what I want to do with it. And I'm a big believer in jumping without safety nets, and so I just jumped. My contract rolled over at work on the 2nd of July, I remember that year, and I just jumped. I was like, okay, I'm done. I'm walking away. And this, I think, is a tribute to the blessed intelligent design of my life, that I've had absolutely no control over it. But literally that week, I received an email from the people who would become my publishers, saying, we've read a little bit of what you've written about IP in the past. So we would like to know if you have something that you would like to turn into a manuscript. And I was like, now that you mention it, I do have this thing that's lying around. Let me see what I can do with it. And that deal came together extremely quickly. I was a first-time author, and therefore I was willing to basically jump at the first offer they gave me and so on. So I was very, very excited about that. And then I made probably the second big mistake in this process, the first being listening to my dad about it to begin with. I made the second big mistake in this process, which was I told them that I'd be ready to submit the manuscript by end of November of 2019. And from the time that we had this conversation, I had 19 weeks to myself. Now, with somebody who has the experience of writing a book and the talent and the ability and the skills and the resources to be able to do it, this would be difficult, it would be uphill, but it would be doable. In my hands, this was a complete mess. I had no idea what to do. And I also, at this point, did not have a day job. In the sense that I had a few sort of spillover clients and people I would do a little bit of work for here and there, but I did not have a job to call my own. And therefore, for those 19 weeks between July and November of 2019, I threw myself full pelt into this project. And I think it's quite revealing of the end product that I don't think any traces of the complete and utter panic that I was put through for those 19 weeks is visible in the final product. I'm very proud of Imperfect Recollections, simply for that reason, in the sense that you can't tell that I was losing my mind while I was writing it. But yeah, I mean, I learned a lot of lessons from that I will both repeat and never repeat in the future, as the case may be. But yeah, the idea then was that you would submit the manuscript by November. so that it would hopefully, and we were innocent of the giant disruption that COVID would play into all of our lives in the year 2020. But the idea, at least initially, was that I would be able to put it out into the market in time for the academic session, which would roll over between June and July of 2020, of the year 2020. Right? So the academic year 2020-21 would be when this book would be in libraries. So that's sort of how that process came about, and how I've been finished writing in November and then editing and so on and so forth. So those are the two broad phases: that initial phase where which came out of that breakfast conversation, and then that 19 weeks of panic, which eventually resulted in the final product.
Got it. That's a very interesting story, Eashan. And so, like, before we jump into the content of this book, I have one more question regarding this process you talked about. So you mentioned that you would sleep at 2, wake up at 6, continue this for the next 4 months to get to the core of the book. But like, did you set some short-term goals that if I'm at this point by this particular date, then maybe I'll be able to sustain this momentum? Because something that I have found is that, like, at the starting of a process, when you are trying something new or actually pushing your limits, you are very excited, very pumped up. But sooner or like as the days pass by, you realize like maybe this was not as easy as I planned, or maybe I don't have everything under control. So how did you sustain that momentum over those 4 months?
So over the 4 months, I didn't actually have this be a challenge at all, because I had no idea that I was writing a book, right? So initially, I had absolutely no idea what I was doing with this. I was just writing it for the sake of writing it. And I think probably the broad, big picture goal at the time was, whenever we had fresh cases that would come to us, especially on the trademark side, we would have to redo all of our research to address the case in front of us. And I realized this is a very inefficient way of doing things. Because if you sort of litigate a trademark case, the majority of the law gets decided at the interim injunction stage. So at the stage where you're determining what course of action is to be taken in the proceeding itself. So in order to do research for those hearings, I realized that we were reinventing the wheel far too much. And I thought that if I had a little bit of a resource in my hands, that I would then be able to replicate with ease, then I would know, that would become a bit of a pathway. And that's perhaps one of the more practical outcomes of that initial research that I did. I think the question that you asked applies more to the 19 weeks that followed in 2019. And there, if you look at the book proposal that I submitted to my publishers and the final product, I think you'll find that there's quite a lot of dissonance, because again, I was pretty disorganized with how I wanted to do it. I was fairly clear that there needed to be 2 chapters on jurisdiction. I was very clear that there needed to be 2 chapters on the similarity question, and I knew that there was bound to be maybe 2 or 3 other chapters. But beyond that, I genuinely did not have an idea, and therefore, I think I sketched out an outline which was probably 10 chapters that eventually turned into 13. And because it turned into 13, I think those adjustments happened along the way. And I did set myself those sort of smaller targets rather. But those smaller targets often ended up being in service of, okay, I don't really know what the big picture here is. And in the attempt to sort of frame that big picture, I got carried away, sort of jumping between chapters or what would become chapters, etc., or areas of research as they were at the time. So I didn't really feel this process particularly keenly, but I have felt it in other disciplines of writing that I've engaged in. So your question comes from a good place. It's just that because of freak circumstances, probably didn't apply to me because of how the book came together.
Got it. So let's get straight into the main content of the book. So particularly for me, as someone who does not have any law background, I think reading this book was both a challenge as well as an interesting journey, because this was completely new to me. So some portions were difficult, but some portions really tickled my brain that why have I never thought about this stuff before? Like, just to start with the first chapter, which is about jurisdiction. So it never occurred to my mind that where a plaintiff can file a case can actually be such a big problem, and there are actually rules defined in law that you are allowed to file a case in this court in this city and not in this court in this city. So talking about what I understood from that law, it was that one part of the law gave a provision that the case should be filed in the city where the defendant resides or carries on major business activity, because to make it convenient for the defendant to defend himself or herself. And later on, another provision was inserted that even the plaintiff can file a case in the city where its principal office is located, to make it convenient for him as well. So how is this dichotomy balanced out in actual court of law, and what is your opinion about that?
Sure. So I think in deference to your non-legal audience, which I assume is the majority of your audience, let's sort of travel backwards in time and try and set up what a what a legal process of thinking actually looks like to somebody who's a non-lawyer. Okay? So I think it might be profitable to break the legal process down, especially with a topic like jurisdiction, but we can apply this across the board. It might be useful to break it down in terms of 3 different stages. Now, I'm just going to give you one rendition of it. You can go backwards and forwards and add steps and subtract steps, whatever you like. But there are 3 broad stages. And I'll sort of explain it with an example that's probably non-trademark so that you understand what I'm trying to mean.
Sure.
Okay, the first stage is the stage of trying to understand what the role of the law in the subject matter actually is. Okay, this is often not clear. So in a rule like jurisdiction, of course, the law needs to determine what the venue of the filing of the case, etc., needs to be, right? But that's a smaller picture question. The larger picture question is how much the law should really be interfering in something. So, and this is a step that a lot of lawyers miss as well. They're trying to understand what the purpose of the law is, and trying to understand this historically, and trying to figure out why this rule came to be in the first place. Okay, so that's stage 1. Stage 2 is trying to understand how that purpose or how that intent or legislative intent, as we call it in the law, how that purpose has come to be embodied in the language of the law, so the legal language that we use. So in this case, the provisions that you refer to, Section 20 of the Civil Procedure Code, and the Plaintiff Option Jurisdiction provisions in the Trademark Act as well as Copyright Act and so on. Okay, so that's the interpretation by the legislature of that original intent that they had. Like, we want to establish this principle in the ground, but in order to establish this principle, it needs to take this form. Okay, so that's the legal language. And then the final stage, which is the stage where all case law enters, is the application of the law to whatever effects and whatever facts are provided to you. And that eventually generates the case law. So the case law comes to you because of the application of the law to certain sets of facts. So you're looking in the final stage towards both effects as well as possibly towards other kinds of broader sort of society-style consequences. Okay. So let's pick up an example that's non-law to sort of set this up.
Sure.
Sort of non-trademark. It's very much a law, for example. So there is a controversy that's ongoing, obviously, as you might be familiar, with a government order that has been passed by the government of Karnataka regarding the circumstances in which it's all right and not all right for women of the Islamic faith to take who take the hijab to be able to display that freedom in public. Right? Everybody's familiar with this. To timestamp this, we're talking in the 3rd week of February 2022. So if somebody comes across this 2 years from now, doesn't know what we're talking about. This is broadly where we are. Okay. So now I don't think for a minute, and I think this is a big arrogance that lawyers have. So I don't think for a minute the consequences, the 3rd stage that I spoke about, the effects and the consequences of this order are not comprehensible to people who are not lawyers. I think everybody gets it. Everybody gets the sort of broader social consequences as well as the more limited mechanical consequences of what this might look like in a classroom, what it might look like in a marketplace, in the public in general. Right? So I give you the credit to understand as well as I do the consequences that we associate with this. However, where perhaps the legal training gives you an edge is one in terms of being able to understand what law attaches. Right? So we're talking here about the application of principles of non-discrimination that is inscribed in our constitution. We're talking here about the individual's freedom to practice their religion. We're talking about the state's duty to be secular towards all people who practice their religion and so on. Okay, so these are the various provisions of law that attach to this kind of scenario. Plus we also have personal laws and so on, which prescribe what rules and what sort of principles of family law and so on perhaps apply to the broader community that practices Islam, right? And then the purpose of the law is actually a very interesting one, right? Because the purpose of the law in this instance is to attempt to balance these things. And this is often the trickiest part. Because if I give you, say, the non-discrimination provisions in the Constitution, you will only read the words on the text. What will be invisible to you is the purpose of the law, is the history of the law, is how that came to be, what those individual words mean, and the fact that, all of these individual words, especially in small articles in the Constitution, which have a lot of history sort of packed into them, every one of those words probably means something well beyond what you might have contemplated. And trademark law is no different from that, and law in general is no different from that. So I thought it useful to be able to set that example out so that we can then talk about this in those 3 stages. Like I said, I mean, I'm not wedded to this 3-stage formulation. You can add and subtract steps. This is just one very simple rendition that I thought to mention. Now, jurisdiction, right? So the question you asked is an interesting one because you touch on all three elements of that framing that I've given you in the question itself. So question 1, what is the purpose of this rule? 2, how does this rule actually look in the language of the law? And 3, what are its effects? Right? So the purpose of all jurisdiction rules broadly in civil proceedings is that you prescribe a term of negotiation that requires the plaintiff to chase the defendant in order to sue for any kind of civil procedure. Okay? This is a rule that we've had since the early 1900s, since we've had a code of civil procedure, which is statutory recognition. And it says so in as many terms. There's no complication there. Where it changes, well, there have been 2 sets of changes, and I'll get to them in turn. So the first addition to this rule has been in the case of corporate defendants. Okay, so the corporate defendant change incorporates again 2 smaller changes within it. It says that if the defendant that you're chasing is a corporate defendant, then you will assume that that entity is doing business, okay, is carrying on business, that's the official expression, that that entity is carrying on business at the place of its principal office, okay. So this is basically a consolidation of the idea that, I mean, the corporate defendant is not a natural person, so you need to have a natural home or natural residence where you can go and sue that entity. In the case of a corporate defendant, we assume that this is going to be the principal place of business, the principal office. Okay, in case it is the sole place of business. However, there is another portion to this rule which says that in the event that the cause of action, which is the set of circumstances that create the basis of the case itself, if the cause of action arises in a jurisdiction where the defendant also has a subordinate place of business, so you can imagine a central office and several branch offices distributed across the country. If the cause of action arises in one of those areas where there is a branch office or a subordinate office, then you can also sue there. Okay, so this expands the scope purely beyond, okay, you must chase the defendant. Now, okay, this is slightly preventative as well. The purpose of the law now moves and expands to become slightly preventative in the sense of the defendant can't be allowed to assume that just because they have merely a branch office at this place, but they clearly have enough influence that the cause of action has arisen in that place, that they can then dodge jurisdiction in that secondary, that quote-unquote secondary jurisdiction. So, or they can dodge legal proceedings in that secondary jurisdiction, more accurately. Okay? So that's the core of what we recognize under civil procedure law. This applies to all categories of law, not just IP. What happens now is that the 2 sets of things proceed beyond this. In fact, if you want a good recapitulation, and I've covered this in chapter 1 of the book, there is a Supreme Court ruling in 1991 called Patel Roadways, which discusses this, and it will be familiar to all civil lawyers, and it's not really an IP case at all, in fact. So Patel Roadways gives us this broad roadmap that I've recognized. In fact, it refers to the idea that there is an or between these 2 things. So if you are in the principal place of business, or in the alternative, you're in the subordinate place of business, but the cause of action arises and so on. Okay? So that is respected very well in Patel Roadways. It says that you can sue either. Now, 2 things happen. The first is that in 2003, when the Trademarks Act of 1999, which came into force in 2003, that incorporated a very curious provision. It said that this rule that we have of chasing the defendant, that you can sue where the defendant voluntarily resides or carries on business, supposedly works for gain, that rule can apply equally in trademark cases to the plaintiff. So in the alternative to going to chase the defendant, you can sue where the plaintiff ordinarily resides, carries on business, or personally works for gain. Okay? Now the history for this is interesting, and this is where I go into the purpose of the law, right? So this is a rule that has existed in copyright law since the mid-1950s. Okay, this has been incorporated in the Copyright Act in the Copyright Act of 1957. And the purpose behind it at the time, in the sense that it applied to copyright proprietors, not trademark proprietors, was that in the majority of cases at the time, copyright proprietors tended to be individuals who were sort of struggling artists, like, you know, that general trope that you have of struggling artists can't afford to make ends meet, blah, blah, blah. So the idea that they would have to travel all the way to wherever the infringement of their work was taking place, whether it be a movie or it be whatever, musical work, performance, whatever it was, it would be difficult for them to be able to sue at the place where the defendant was carrying on business or personally working. Okay? So as a concession to those artists, the provision was incorporated into the Copyright Act in 1957. And that law proceeded in parallel with the standard rules that apply to trademarks that you have to chase for patent. Okay? That crossover then happened in 2003 under the new Trademark Act. And it's interesting because the explanation for why this extension happened from copyright law to trademark law is not explained. Okay? So, or there is no explanation rather. So there is no explanation of this in the 1993 initial draft of the Trademark Bill that would eventually become the 2003 law. There is no explanation of it in the parliamentary debates that took place in December 1999, which eventually led to the incorporation of this bill into an act and so forth. There is no parliamentary standing committee report which discusses this. There is no mention of it in the notes to clauses. There is no mention of it in the arrangement of clauses. Nothing of that nature. Okay, just quietly, silently, this thing that used to apply purely to struggling artists gets expanded to also cover trademark proprietors. Okay, this is interesting. Why? One, you can argue with the framing of all artists as being struggling artists and so on. I'm not going to argue the point. This law came into being like 30, 40 years before I was born. It's quite possible that artists were in fact struggling then as they are now, blah, blah, blah. I'll concede, okay? The question we need to ask is, one, why does this benefit now need to extend to trademark proprietors? Because in a vast majority of cases, trademark proprietors do not answer to the description of being struggling artists, right? If anything, it's the other way around, in that the majority of cases, trademark defendants are those entities. The entities who are small entities, businesses who can't afford to litigate in other jurisdiction and so on, okay? So this extension of what we call the plaintiff option jurisdiction clause, that you can sue either at the convenience of the defendant or the convenience of the plaintiff, came to be incorporated very silently into our trademark law in 2003. Okay? Something else happened at this time. This new Trademarks Act, and this is a theory that gains leverage more and more I think about it, is that the Trademarks Act was almost perfectly timed with the rise of the internet as a form of doing business. Okay? And so what happened is, once this plaintiff option jurisdiction kicked in, businesses started to expand to not just cover physical places of business, but also sales that took place online and so on. Where this question of where you carry on business and personally work for gain, etc., becomes extremely complicated, because by definition, the law has refused itself to be able to cover this larger area of meaning, right? So what you mean by carrying on business at a physical location is very different from what you mean by carrying on business online. So if you put it in today's context, if I'm a seller looking to sell products on an online platform, I could technically be said to be doing business literally anywhere in the country, right? Because I'm going to be delivering products anywhere in the country. Now, this is a process that it has taken us a little bit of time in the law to be able to fully adjust. And you'll find the law, and I've referred to this law in fairly great detail, in both in both Chapter 1 and Chapter 2 of the book. In the sense that you have like Buddha House in 2005, you have Tower and KR in 2008, and so on and so forth. Okay? So there is a slow process by which the law has eventually started to adjust. The end point of this, the logical end point of this, arrived with a case called WWE and Reshma Collections in 2014. Okay? This is also something that I discussed in the book. And the consequence here was so extreme that you had to almost sort of give up your hands in just complete absurdity and say, well, what is this, right? So this was an instance where an entity that was local entity that was based in Bombay, with very little internet presence, was sued in the Delhi High Court and was injuncted in the Delhi High Court from selling its products, largely in the Bombay area, by the way, by WWE, the pro wrestling company, which did not have any offices, or they didn't plead that they had any offices in India at the time, and they were therefore a US-based company. They managed to make the suit stick in Delhi on the basis that consumers or potential consumers of their own, of WWE, could theoretically order products from the WWE store in the United States that would be shipped to India. And that location included, that set of locations that they could ship to in India included Delhi. Okay? So this is basically like you're taking a variable upon a variable upon a variable, and you're stretching that piece of string as far as it will go, to the point where the entity who's sitting in Bombay has literally no idea this is even going on. They have no sphere of influence. They have no technical, technically they have no business in Delhi. They probably don't even want to expand there, nothing of the sort. But purely on the convenience of the plaintiff, and you notice how extreme a convenience it is and how extreme a definition of convenience it is. This ended up becoming the law. And what we have, therefore, in the last 8 years or so, since that initial ruling in 2014-15, what we've had in the last 8 years or so, including attempts by the Supreme Court, is an attempt to sort of pull it back from that street. Is to say that perhaps that is not what was intended. but we intended to be a slightly more rational, slightly more reasonable ruling. And then in chapter 2 in particular, I get into great detail about how this has happened via the Supreme Court and IPRS and Ultra Home Constructions, the Delhi High Court rulings, and so on and so forth. So it is a very complex area of law, but that complexity arises, one, from the fact that we incorporated a provision into trademark law that it probably wasn't ready for, and the other is that using that flexibility, we managed to stretch that flexibility as far as we go to the point where it produced a fairly absurd result. In fact, I remember at the time when we read Trademark Recollections, if I was, to me, it felt very much like if I was a constitutional lawyer in the 1970s and the emergency was imposed. Right? I lost my mind. I was like, what is this? How are we supposed to argue out of this? Because there is no limitation in that sort of ruling to say that I can basically sue anywhere, literally anywhere, right? Because the website is accessible pretty much anywhere. And that's sort of where we ended up, and that, like I've described in chapter 2, the last 8 years or so have been an attempt to sort of drag the law back into slightly more safe and reasonable.
Got it. So let's move on to the next part of the book, which basically talks about registered trademarks and what exactly can be registered and what word or sign or mark cannot be registered. So in the book that you have this line where you say that a generic mark can never be a trademark. A descriptive mark can become a trademark if it acquires secondary meaning, and a suggestive mark is inherently distinctive. But this also leads to the problem wherein some words start as distinctive, something like Google or Xerox, which started as completely distinctive registered trademarks, and then over time they entered normal English language uses. Like we can refer, I am Googling something, or I need to get 2 Xeroxes of something. In a very casual conversation, it became part of the literary jargon. So, and a lot of companies also adopted these words in their marketing campaigns and their taglines. I particularly remember one toffee saying that we are Kache Aam Ka Xerox, which is essentially using their brand's trademark, even though in a completely different sub-market. So, is there any laws against this? How do these companies approach this? You also mentioned you have worked on the Xerox case, so if you can share some stories around that.
Sure. Okay, so this flipping of what we call ubiquitous marks into common parlance and the loss of their trademark function is referred to by trademark lawyers as genericide. Okay, so it's a very clever play on words. Yeah. It's basically losing to genericide, excessive use of a trademark to the point where basically a trademark becomes too famous for its own good. Okay, so you can imagine this again to just go back to the purpose of the law, and we'll follow that structure throughout. The purpose of the law here is to try and determine the appropriate kind of protection that you should afford to trademarks of varying qualification and varying preeminence. Right? So if you can imagine it as a bit of a pyramid, where at the base of the pyramid you have any and all trademarks that are reasonably distinctive to the point where they can distinguish somebody's products and services from somebody else's. Okay? Beyond that, you have a level. The level above is probably the level that you would identify under Indian law as what we call well-known marks, which are known abroad as famous marks. So these are trademarks of certain preeminence, where say you have, and in India you have several examples. Tata is a good one, where the Tata Group is associated with the Tata trademark, and therefore any use of that in a wide variety of Tata, Reliance, whatever you like to use in this context, a wide variety of products and services, because that is the competence of the company. You will notice that these trademarks tend to get a certain preferential treatment in the law, and those preferential treatments tend to be in the form of they don't have to, for example, lead evidence in every case that their trademark is well known and like an interpretation of Tata that could possibly be confused, blah, blah, blah. Whereas somebody who is less well known will still have to establish that there is a likelihood of confusion here, and that there is a possibility that my goodwill will be injured. Whereas in the case of a well-known mark or a famous mark, we are far clearer about what the immediate sort of legal consequences of violating a trademark of that nature. Now, perhaps even at the level above that, and this is a level that remains hidden to a lot of people, are the trademarks that fall into genericide. The trademarks become so popular that it sort of bleeds over into common parts. Okay, and so one thing to flag here, and I don't know how this fits into the conversation necessarily, but the reason we don't really have a lot of strong domestic law around genericide, I think one of the reasons is that genericide, by definition, because it bleeds over into ordinary conversation, tends to be a cross-jurisdictional thing, right? So the reason why, for example, Googling is such a thing is because everybody in the world uses Google. It's not just the fact that it's in India. Although, I mean, I don't need to pretend that, for example, eventually in time, say, Swiggy might not become might not fall into that kind of genericide as well. It's an Indian company, largely based in India. But you have several examples. You have Googling, I'm calling an Uber, I'm whatever. Like there's several examples to think of here. Right? So the challenge in these cases is being able to identify how and where the law should actually step in, like I mentioned. And therefore, what the law does is that it requires a particular scrutiny in cases that are at risk of genericide. It requires a particular scrutiny to the kind of actions that the proprietor has taken and the acceptability of that trademark as general use, in contrast with the understanding that is in fact a trademark. Okay, so I'll explain what I mean by that. Okay. So let's pick up that Xerox example. I have a little bit of experience doing working on that case. It's one of the first cases that I worked on when I joined legal practice. So we're going back about almost 10 years now, in fact. So this was literally the genericide challenge to Xerox. It was, look, Xerox has become a generic trademark because everybody says Xerox. In fact, that Kache Aam Ka Xerox example that he used, it was literally one of the exhibits in that. They printed out that advertisement and they said, look, this is Kache Aam Ka Xerox. Okay. So the question here, therefore, for approaching what would look like a reasonable approximation of what fair law here should be, required us to examine two broad issues, and I think this is largely where the law on genericide has fallen, at least in India. The first is the company itself doing something, or the owner of the trademark, it need not be a company, is the owner of the trademark itself doing something to perpetuate this genericide? Okay? So is Xerox, in this instance, is Xerox itself using Xerox generically? Is it saying Xerox machine? Is it saying, you can Xerox this? Is it saying, is it contributing to that use? And what we noticed in this instance, and I say this completely impartially as far as the case is concerned, you can find the judgment online, is that Xerox was in fact going to great lengths in the opposite direction. It was in fact going to great lengths to identify the machines as Xerox copiers. It was going to great lengths to say that the product from a Xerox from a Xerox copier is a photocopy. It's not a Xerox. So things of that nature. That's one factor to be considered. Because sometimes, if for example, I don't mean to pick on Swiggy here, this is the first example that comes to mind. If I were as Swiggy to start incorporating into my ads a tagline to the effect of just Swiggy it, then if somebody else starts to use it, and then somebody else who's dealing with food delivery or grocery delivery or whatever starts to use Swiggy in that context, I can't really complain because I started it, right? So my conduct here is relevant. So that's one set of things that needs to be considered. The other set of things, and this is far trickier because it changes quite dramatically from individual instance to individual instance, is there a public acknowledgement of the fact that this word that we're using is a public acknowledgement that it is in fact a trademark? Okay, so if there is a public acknowledgement to run parallel to the quote-unquote generic use, then you might still be able to save the trademark from genericity. Okay, and this is again something that Xerox did a lot of work in trying to be able to put together evidence to show that even the entities that, for example, several government agencies, and a lot of evidence filed against Xerox in that case, a lot of government agencies, a lot of courts, a lot of private businesses, a lot of like that Kache Aam Ka Xerox, those kinds of examples, a lot of those entities, when confronted with their sort of quote-unquote generic use of Xerox, were very willing to say, we're sorry, we recognize that this is your trademark, and we won't do this in the future, right? So everybody knows, and it's not just under the threat of legal proceedings, but everybody was willing at some level to acknowledge that Xerox is a company. And that has made these machines and used to make what we used to call Xerox paper, because there used to be a time when, ordinary paper was not susceptible to being photocopied, and therefore you had to and so on. And the other thing, and perhaps the third thing that I omitted to mention previously, was that competitors in the market were not actually doing this. So, for example, if you had HP or you had Samsung or whoever else was making photocopiers, they were not referring to their machines as Xerox machines, because to them that would be counterproductive, right? So they were referring to those machines as copying machines or copiers or 4-in-1s or whatever else they used to call them. So those elements all got factored in by the courts. And the other sort of capping argument, it didn't find a lot of play in the eventual ruling that came out of the court. But it struck me as perhaps being the best articulation of Xerox's case, was the idea that Xerox is actually not led over so much into genericide, as much as it has bled over into what we call metonymous use, where an attribute of the product is used as the name of the product itself. So, for example, if you say suit, you mean basically business executive. Okay, so if you say Xerox machine, everybody knows you mean copier, even though you're using that term as like a carry-on to sort of represent the attribute of the machine. Okay, so those were the factors that got considered, and I think you find those kinds of examples. But it was a fairly exciting case to work on fairly early in my career as well. I think simply because we managed to dig out so many of these old Xerox advertisements and stuff, where they'd been aware of the genericide problem for several years and had been consistently acting against it. So we managed to pull out all these old ads where they used taglines like if you use Xerox the same way you use aspirin, it gives us a headache, and so on. So there were several of these advertisements, very clever sort of witticisms that they've used, and they've been consistently putting out the message that you do not use Xerox as a synonym for photocopy, and I think that weighed fairly heavily in the court's finding that you could probably save Xerox from genericide. But you'll find, as I narrate this to you, you probably think of several instances where a trademark will fail that test of genericide, right? So they won't be able to meet these conditions.
Got it. So now I have a kind of a hypothetical question which just came to my mind yesterday. As I was talking to a friend. So he told me that he had worked with a company whose name was Reliance Footwear, and it had nothing to do with Reliance Industries at all. And so the question that came in my mind was that, is there any instance where Reliance Industries could sue Reliance Footwear if it feels that Reliance Footwear has acquired a bad brand image or bad name in the market? Or could it also be the other way around, where Reliance Footwear feels that just having the name Reliance is negatively affecting its business because of something that Mr. Ambani did or something to that extent? Is that even possible? Like, how does that work?
Okay, so the latter of those is slightly tongue-in-cheek. I'm not sure that you will find a clear, predictable answer to that question. But I think the first part of your question is an interesting one, because again, to go back to that pyramid that I discussed, so Reliance is very firmly in that famous mass or well-known mass level of the pyramid. Okay? So one of the benefits, and I mentioned evidentiary benefits previously, one of the evidentiary benefits involved is that Reliance gets protection across classes of products. So even though it may not be primarily associated with footwear, but because the trademark has reached that level of preeminence, the presumption in the law is that anybody who uses that trademark for whatever products or services that is unaffiliated with Reliance, the principal brand, is likely to damage its goodwill or its reputation in the marketplace. And therefore, that coverage extends across classes. This is one of the principal benefits of a trademark being recognized as well-known or famous. So one of the key pitches in a case like this will be that, look, Reliance has attained this status, and this status in the law permits me to be able to act against somebody who's got, say, a footwear brand and so on and so forth. Okay, and then later on, perhaps you could look to is there actually evidence that that people will associate that trademark with Reliance and so on, and perhaps with a less famous mark or a trademark that is less well known, this question will be answered very differently, because the protection in trademark cases usually extends no further than the class of products or services in respect of which it is protected. So with a trademark other than Reliance that doesn't have that level of preeminence, you get a very different answer.
Got it. So let's talk about the next aspect, which is basically what are the, like in the book you mentioned that trademark cases can be broadly divided into two categories. Either it's a passing off case or it's an infringement case. Yeah. Infringement is something that we have been talking about, where you are using the same trademark or something very identical or similar sounding that might confuse the buyers. Passing off is something different, wherein even like your trademark could be different, but your getup, packaging, color scheme, and all these are so similar to that product that it can lead to misrepresentation of the brand and be deceptive to the consumers. Right. So how if you can like simplify what is the distinction between these two, what do brands approach? Are the legal remedies available in both these cases completely different? And how do brands go about it?
Okay. So you've understood this topic really, really well. It's a topic that a lot of lawyers have a lot of trouble in understanding as well. So I commend you for having read it accurately. So infringement in trademark law, unfortunately, is one of those terms that probably in the trademark law context has slipped into genericide a little bit, because we end up using infringement when we mean a bunch of other things. Yeah? That's fine. But okay, so again, I'll give you two broad differences between passing off and infringement, and again, you could add and subtract things to this. But I think to a non-legal audience, I think the two most important things are, first, trademark infringement is coextensive with a registration of a trademark. Okay, you cannot sue for trademark infringement without a trademark registration. This is an absolute truth. Okay, in a subject of law where there are very few absolute truths, this is one of those. Okay? Whereas passing off is typically more associated with unregistered trademarks, because you can acquire goodwill in a trademark that you use in the marketplace that is not yet registered. So the law doesn't require you to register a trademark under all circumstances. It is probably better that you do so. But if you don't do so and you have use that dates back and you have continuity and so on and so forth, you can in fact get it protected under passing off. So that's one distinction, registered versus unregistered. The other point of difference, and this is actually quite interesting because it can vary in context and so on, is that the foundation for a passing off action actually comes to us from the old English law. And the foundation for the action is the idea that there is something deceitful about the representation of the defendant. Okay, so you're looking for an action that is, and this is something that we call an action in equity. Equity being the legal sort of jargon for an action in fairness or justice or things of that. Okay, so it is unfair, broadly speaking. It is unfair if somebody uses my trademark in a deceitful manner, or uses something approximating my trademark in a deceitful manner, and misrepresents to the public that they're associated with my business, even though they're actually not. Okay? Whereas trademarks, whereas infringement rather, passing off on one hand, infringement on the other hand is slightly more predictable, slightly more clinical. It is based on statutory provisions that spell out in sort of very in mathematical terms that will appeal to a lot of your STEM audience. It'll appeal to you in the sense of, okay, this is, if it's an identical trademark and there are these many products and services that are in common, then you can either presume likelihood of confusion or it will attach that. Okay, so it's a provision that works by the elements. So if the elements of the crime are fulfilled, so to speak, then there is infringement, and there's very little that you need to travel to beyond that. So the way I found most instructive to sort of understand passing off infringement is to think of them as two concentric circles. Okay, and I beg you again to not press me on the details of whether or not they're exactly concentric circles or not. Because we'll get into the weeds of this, and we could talk about this for days. But the idea is that trademark infringement is broadly the inner concentric circle, and the larger outer one is the one on passing off. Okay, so in all instances where there is a registration and there is those elements are hit, you will probably not only have infringement, you will also have passing off in those terms. Okay? However, pure passing off can occur in situations where, for example, you're either unregistered or where there is an action in deceit, the broader action for misrepresentation, where there is damage to your market reputation and so on, which need not necessarily fall within the domain of trademark infringement. I'll give you an example just to make this clear. So the Coca-Cola logo, the one that you're familiar with the stylized writing and the white lettering on the red background, etc., that will typically prompt an action for both trademark infringement and passing off. Okay, so that's within the inner concentric circle. Because Coca-Cola is a registered trademark of the Coca-Cola company, you would have heard this in advertisements a lot. Okay, and if you're using, say, something else on a red background which uses similar style lettering or whatever in the relation to whatever product, it's very likely that it will also constitute passing off because it is deceitful use that causes damage to the Coca-Cola. Okay. However, you could, for example, have and this is one of the more extreme examples. The first one that comes to mind is that, for example, you could have set up a restaurant, okay, where the layout of the restaurant is such that there's a bar at one end and there's a couple of chairs, there's a large French window, there is a salad bar, there's this and that, and the whole thing is painted in a combination of garish pink and garish yellow. Okay, so if you're traveling into the future, say 200 years from now, all restaurants will look like this. Or if you want to travel more realistically, the early 2000s, I know for a fact that a lot of restaurants look like this. Okay, now you could look to imitate that setup, right, with, say, garish blue and garish green. And if the elements of that restaurant setup are broadly the same, you'd be shocked at how identical the two look, right? To the point where they might cause confusion. So what you're looking at here is that you're not protecting a trademark. There is no use of trademark here that's going on. There is no Coca-Cola versus some variation of Coca-Cola. But what you're looking at is a deeper, more fields-based, look and feel kind of test, where you're looking at the elements that constitute something that is distinctive to a proprietor, and then you're contrasting that with similar elements, not exactly the same, which convey broadly the same impression. So we have cases on restaurant setup and layout and stuff, which have been protected under passing on. Okay, so that's a good example of what exists in that penumbral area between the concentric circles. So I thought I'd clarify that, because broadly the terms of the terms of engagement that the law has engaged over the course of the last, say, maybe 60 years or so, have recognized this very early on. In fact, you'll find in chapter 5 and 6 in particular, I get into how clear the law has actually been on distinguishing between passing off and infringement. But at the end of the day, because the reliefs associated with them are largely the same, they tend to overlap and they form these concentric circles where the core of the protection is largely identical in all of these cases.
Got it. So, like from the definition of passing off, I think it also sounds very similar now to something that I read on your blog yesterday, which is about trademark stacking. Wherein you gave a particular example of fantasy sport leagues like Dream 11, My Team 11, My 11 Circle, which basically focus around the word 11 and some permutation combination of it, and all have similarly red and white-ish backgrounds and font letterings. To convey that they might be trying to passing off, but they might be clever enough that they may not get into a legal suit because there is also significant differences. And the impression that I got from reading your article was that you were not very impressed by what these companies were doing. But this is something that I have observed in other industries as well. So, like on the recent trip to Rishikesh, I saw that the river Alaknanda flows through Rishikesh, and every food joint in Rishikesh is named Alaknanda Eateries or Alaknanda Food Joint or something like that. So the impression that I found, probably from a business perspective maybe, is that if you have very low points of differentiation from your competitors, it's better to aggregate to a common set of image that the consumer can relate with, like focusing on Alaknanda or focusing on that we are all talking about cricket and 11 players and making a team. That is why Dream 11, My 11, Team 11, all these kind of names came up with. So what is your opinion on that? Is the law so harsh on these kind of activities, or does it allow these companies to get away with it?
Okay, so I think you've rushed into the same category two actually reasonably distinct examples. So one is your Alaknanda example, which I think you can probably say falls into that nether region of trademark use, where, for example, if there is a city which has a giant lake, and there are like 15 hotels that are around the lake, all of them will have some version of, this is Hotel Lake View, this is Hotel Lake Point, this is Hotel whatever. That's fine. I don't think that's actionable. I don't think it should be. It would be a really small world and very petty world indeed if we started to sue all of those people in the word lake, right? But the Dream 11 and sort of competitor leagues example is quite an interesting one, because I think what you have to weigh against the idea that they're at least in partial imitation of the core concept of the game, is that there is a hard limit, and we see this in a completely different context in pharmaceutical products as well, which I've written about in chapter 6. But we see that there is only so many ways you can skin that cat, right? So if you're trying to convey via your trademark what your product is in the context of something as constricted in terms of gameplay and format as fantasy sports, I think you could make the argument. I'm not very partial to it, as you know, but I think you could make the argument that this is nominative use, in the sense of, what else do I call it? Like, I'm supposed to call it this, because there are only so many things that I could possibly call it, right?
Yeah.
And the other thing to be stacked in this direction is the possibility that, obviously you can refer to Dream 11 as a market leader, but there are several other entities that do very good business in this field. And I don't think you can rule out the possibility that all of them have some kind of goodwill that is now built in. So, for example, if I started on My 11 Circle 3 years ago, assuming it was in existence 3 years ago, if I've built up a lot of loyalty in that brand, then to me, My 11 Circle is a distinct thing. There is goodwill that resides in my mind and in my business with My 11 Circle that recognizes it as a distinct trademark. And there is a certain sort of commercial value that is associated with the use of My 11 Circle. However similar to me otherwise on the surface find it to be with Dream 11, right? So in that universe, you're probably okay with Dream 11 and My 11 Circle coexisting. But if it gets to be 5, 6, 7, 8, 9, 10, 11, 12 people, then it becomes a problem, right? Because then you're like, okay, what are you doing? All of you are clearly inspired by the same thing. And then I guess as one of the market leaders, you're probably the one who's damaged by it, and therefore you can look to those actions. So there isn't, unfortunately, a very good answer on this, but I just sort of thought I'd sketch out for you a couple of pathways where this could lead to in the future.
Got it. Yeah. So let's finally come to the core of the argument on which trademark law resides, which is the argument of a hypothetical purchaser and how that particular purchaser will distinguish between two conflicting brands or trademarks, to say. And from your book, I think I got the feeling that I could club them into three categories, basically, wherein the law approaches them. One is that of a hypothetical purchaser, which is basically a narrative that maybe the court or the judge or the lawyer said that this is most likely to be the customer with these many attributes. Second was someone who is a more discerning purchaser, like who is most likely to be the purchaser of high-end products, who maybe has the capability to distinguish between similar sounding or similar looking trademarks, just because he's a more conscious user of the product. And third was there was also cases where the court deliberately assumed that let's assume that this guy is maybe not that literate or maybe has trouble distinguishing between phonetic sounds. Maybe he is or is not the user of the product, but there's a large audience present there who might want to try this product and maybe they would not be comfortable distinguish between these slight nuances. So the idea from where I'm approaching this question is, in behavioral sciences, we study a concept called anchoring bias, wherein the narrative that you establish first kind of leads on the entire discussion and it becomes the talking point. So especially when these kind of discussions play out in a court, because this is a very subjective area, is there any anchoring bias involved? Who sets this narrative? And because, at least from the reading of the book, I realized that this is a slightly gray area and there's not as strictly laid down rules as possible on who exactly this purchaser would be.
Right. Okay, so the hypothetical purchaser is interesting because it was introduced into the law, and again, this is something that we've inherited from the British. It was introduced in the law as a wedge against subjectivity, as you correctly identified. Okay? So I don't think there are necessarily three categories in the way that you frame them, but I think there are more points on a spectrum. I'll try and explain what I mean by this. Okay? So the hypothetical purchaser, in the terms of one of my favorite English cases from the 1920s, says that you cannot assume that the purchaser, while pronouncing the name of the trademark, will have the same kind of clarity and diction as that of a teacher of elocution. Okay, so the idea is that you're slightly less than that standard. So it's not as if the consumer has perfect knowledge or perfect ability to articulate their own impression of a particular product. Okay. So the reason I think it was brought in, and again, people disagree on the exact sort of origins of it, and you'll notice here again, I'm referring back to the purpose of the law more than the actual interpretation. But the purpose of this law was to try and give judges something to work with. Okay, so the idea was if you leave judges to run free in terms of being able to say, okay, trademark A is similar to trademark B, one judge will rule one way, the other judge will rule the other way. There'll be no certainty in the market. It's going to be extremely difficult for everybody to be able to agree on what these core principles of trademark similarity, etc. are. So hypothetical purchasers in general are a wedge against that kind of subjectivity. There's a series of principles that you can look to say, okay, there's going to be some uniformity and consistency here if we all have the same sort of core meaning of all of these expressions. Okay? So that's one thing to say. I think the way to probably think about it, and I'll try and incorporate as much of a response to your question within this analogy, is that a hypothetical purchaser is something that you can look to as having. It's like the hands of a clock. Okay, so an analog clock. Okay. There's an hour hand and a minute hand. And the hour hand here is a reference to the product or service in respect of which there is a contest between, say, two trademarks. Okay, and the other hand is the sort of core, the underlying idea, where you mentioned anchoring bias and so on. This fits within the general definition of what is the idea sought to be communicated by the two trademarks. Okay, and the premise of the hypothetical purchaser is that you are going to use these two factors, the hour hand and the minute hand, to try and approximate what time of day it is. Okay, so it's not an exact science in the sense you don't have to tell that it's exactly like 3:10 or whatever time in the day, but to get a general idea that it is probably the afternoon, right? So that kind of thing. So as far as the products and services are concerned, the first sort of element of this test, I think we find that we have a very broad tolerance for what we can assume to be knowledge on behalf of consumers who purchase certain kinds of products. and this is a detail that I've gone into at considerable length in chapter 6, is trying to understand that there are certain consumers that you cannot take a chance with because you cannot assume that they know too much about the product that they're purchasing. Or there are certain consumers you have to be protective of because the products themselves are potentially, if misused, so dangerous that you don't want to risk that consequence, even if the consumers themselves are reasonably well aware. Okay? So in this category of products, you see both in at least the early law used to refer to a lot of English language trademarks, where the assumption was that the product is being sold to people who don't have English language knowledge in India, which is a big problem in the 1950s and 60s in particular. Then you don't necessarily want to be protecting. You don't necessarily want to be protecting those kinds of trademarks because people won't be able to distinguish and so on. Okay? The other difficulty, the deleterious consequence difficulty, arises in the case of pharmaceutical products. It's an example I used previously as well. So even if the two trademarks are what you would normally call reasonably distinct, like you and I could probably tell them apart, but because they're going to be communicated by a chemist, it's going to be written down by doctors, it's going to be this, it's going to be that, there's several sort of links in the chain where confusion could arise. You don't want to risk the possibility of those two trademarks being in the same marketplace, lest they get confused for each other. Because if you consume the wrong medicine, it's obviously going to be a bad thing, right? So that's on one end of the scale where you're sort of lowering the standard, where you have a soft touch trigger. Okay? There is also on the converse end of the scale, this is why I refer to it as a gradient of a continuum, is that on the other end of the scale, you have discerning consumers. And this is an example that I picked up at great length because there is Supreme Court case law on this. The example of, for example, consumers of premium products. So people who consume liquor or people who consume, premium liquor, people who consume premium, say, certain publications that are only published and so on. Okay? So if there are two trademarks that sound reasonably similar or evoke the same idea in this context, then you can probably trust the consumer. You don't have to be as paternalistic towards such consumers because you can assume that they'll be able to tell even differences between smaller factors that would otherwise confuse other sets. Okay? So those are sort of two areas where you broadly land. And in the middle, obviously, you'll have fast-moving consumer goods, you'll have services, you'll have I don't know, other kinds of business. You'll have like financial instruments, advertising, blah blah blah. Okay, so at different points on that continuum, you need to be able to identify on the first hand where you're talking about the product or service, what part of the gradient does it lie on, and adjust your understanding of the hypothetical purchaser to account for those either deficiencies or those aggrandizements, if you want to call it that way. Okay? The other end of the other hand of the clock, so to speak, is a discussion of what we call the essential features of the trademark. Okay? And this is a conversation that has actually shifted quite dramatically in recent years, and it sort of feeds into all the stuff that you spoke about, behavioral sciences and so on. So in the 1960s, as early as the 1960s, in fact, the Indian Supreme Court was able to set out, look, we're not going to compare every individual element of two trademarks. We need to look at the essential features, the broad impression that they convey, and then judge similarity on the basis of that. Whether a hypothetical purchaser who doesn't have the elocution and diction of a teacher of elocution, blah, 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 if that person will be able to successfully distinguish between the essential features. Okay, if the essential features overlap, then there is a case for trademark infringement or passing off the case. Okay. However, we are now in a position where we are willing to give consumers a lot more credit than we used to in the 60s. Okay, because not just the modes of communicating and marketing, etc., of messages have changed, but also because consumers are more aware and people spend a lot more time purchasing things. People are a lot more careful with their money, presumably, and so on and so forth. Okay, so we are now in a position where we have a series of cases, and I discussed this briefly in the book as well. Although they're high court cases and not Supreme Court cases, so we didn't get the royal treatment, so to speak. But where you can look at, for example, one of the cases involves shaving razors. Okay, where there are two trademarks with completely different trademarks, but they both use the device of a sword. Okay. And a sword is a bit of an allegory to like a shaving razor. So the idea that one was in the market previously and already used the device of the sword and evoked that imagery was used as a bit of an anchor to say that the later user, even though the later user was under a completely different trademark, and if you asked for it verbally, if you asked for that trademark verbally, would be supplied to that product, the visual assumption on the basis of comparing the two trademarks was such that the central idea of those trademarks, look at the essential features, the central idea of those essential features was broadly the same. You're then extending trademark protection to what is the underlying idea of those two trademarks as well. Okay, so that's it's controversial, but it's also very interesting because I think that is where trademark law is probably heading in the future as far as the hypothetical purchase is concerned.
Got it. Now, I just have a question that, as a Delhi resident, has been stuck in my mind for some time. So in Delhi, there's this coffee chain called SardarBaksh Coffee, and it has a logo of a Sikh with a turban, and that's why the SardarBaksh term came in. But phonetically, it also sounds very similar to Starbucks if you say it in a quick succession. And like I remember reading 3-4 years ago, I think that Starbucks actually filed a case against this coffee chain, and they had to change their name to Sardar G Baksh Coffee, so they had to insert that G in between. Now, as a consumer, like maybe I'm biased towards SardarBaksh Coffee, but like the reason I understand is that as if I invoke the argument of discerning purchases here, I can understand that Starbucks is definitely a premium coffee brand in India, and the logos, the names, the format through which they sell are completely different. So even then, like what could be the possible reasons that like this judgment was passed or they had to change their name?
Okay, so I'll give you a counter example, which is almost exactly the same thing because it also refers to peaks and it also refers to fast food. There was a similar case that occurred also in the Delhi High Court between Burger Singh and Burger King. And there they were able to sort of get out of it by reaching some kind of arrangement that they would continue to use the trademark, but not certain other elements of the trademark. So I think the question that you asked from a hypothetical purchaser standpoint is an interesting one. Because if the consequence of the case was that the defendants had to make an adjustment, like the Indian defendant had to make an adjustment to accommodate for the image or the central idea of the foreign slightly better known trademark, so to speak, then that's probably a reflection of the fact that the hypothetical purchaser was interpreted to be at a level slightly below the level that you sit at, right? So you are able to distinguish it because you think you see it. Right? But if somebody is slightly below you on that level of awareness, again, I hesitate to correlate this with education because I don't think this is a factor of education. Courts often very erroneously assume that it is. But awareness is a very subjective thing, and I think you could come to a conclusion here that that perhaps the average person is a person slightly below the level that you're assuming yourself to be. Whereas in Burger King versus Burger King, you might end up, slightly. You might arrive at a slightly different outcome. Where again, the hypothetical purchaser would be pitched at a slightly higher level to be able to say, okay, fine. These are both acceptable outcomes here. And you don't have all judges rule one way. But as far as tagging this conversation to the hypothetical purchaser is concerned, I think it would really be a factor of how well that is pitched in.
Got it. And one other aspect that comes with trademark law, which you have talked about in your blog, is companies filing frivolous cases that might seem not at all necessary in the first place. Something that you talked about in the Dr. Reddy laboratories versus Eros movies, because they depicted a fictional township called DRL Township in their movie, or CFA versus BFA Academy, wherein CFA is a much larger brand with a much more global presence, and BFA probably seems like a domestic certification course-based academy. So I wanted to understand from the perspective of a company that what exactly does DRL has to gain by filing essays, even if they win? Like there's no business overlap, or it's not that their brand or reputation is at stake in a more tangible way. So why do such large firms still continue to fight these cases?
So I think the DRL one is a rather extreme example because I don't think I could give you a very good reason. But I think there are two broad motivations. Okay? The first is actually a performative motivation, is that you want to be seen as somebody who aggressively protects your trademark. Okay? And I think this can bleed over into a lot of types of action. And it's very good evidence, in fact, of well-known use and sort of attaining that status of a well-known trademark, that you are aggressively litigating and aggressively pursuing all potential infringers, however distant they may actually seem on the ground. Okay? So that's one very clear motivation. The other motivation is that it's just, in a lot of these cases, I think you could just arrive at the conclusion by looking at the pure elements of the law. So if you were to look at, in your CFA, BFA example in particular, if you were to look at, is this trademark infringement? And you were to look at identical products and services, similar trademarks, or reasonably identical trademarks, you are the senior user, whereas the defendant is the junior user, and so on and so forth. You could probably create a case on the elements. You could say, you know what, Now you think about it, it should probably stick in a court. And a lot of actions just get filed on that basis. The basis that you could make it work under the provisions of the law. Whereas if you were to look at, sort of take a more broad-based business style perspective, is to say, does this really matter to our life? Are these people really infringing on our trademark in any meaningful sense and so on? You would probably come to a different conclusion. But a lot of those decisions are not made with cool heads, right? A lot of them are made out of a go-getter mentality and then trying to be able to assert trademarks over and above everything else in the marketplace. And the reason this is important, I think, also to give such plaintiffs a little bit of credit. I think a big reason for something like this is also to do with the fact that that there are legal consequences associated with not taking actions as well. Okay? So I think that obviously it's good to take action to be able to demonstrate that you are aggressively protecting your trademark. But you could also make the case that if you don't, then you could set up cases, or you could set up an argument for the other side to say that, well, we've been in business for 2.5 years, why haven't you done anything? We have been in 5 years, why didn't you do anything? And that sort of feeds into our discussion that I've discussed, in chapter 10, in particular, of delay and acquiescence and how all of that feeds into the law. So you want to be clear, basically. You want to be clear that you are taking action continuously so that there can't be a later assumption further down the line. You're basically securing your future assets. There can't be an action later against you to say that, well, there was also this third party who didn't take action against.
Got it. So now, just to shift the discussion a little bit now. So whenever you're writing something, I think whenever you're doing something creative in general, feedback taking is a very critical process. And as an artist, you're also protective of your work. You are averse to criticism, to say. I personally feel that whenever I do something new, I don't generally like people coming up and criticizing me because I put in a lot of effort in that. But you specifically mentioned in the preface, even in the acknowledgement phase, that you benefited a lot from feedback by talking to people you have worked with, by talking to your colleagues who gave you a genuine review of this book. So how did this feedback process help you in framing this book for both good and worse? What's your opinion?
Okay, so I think this feedback and being receptive to feedback and so on is a bit of a personal trait more than it is a reflection on how much work is really involved in the process. And I've taken great care at all stages in my life and not just professionally to make sure that I'm surrounded by people who are extremely critical. Okay, so this whole thing about your friend should be supportive and your friend should back you up and love you unconditionally and all of that. I have very limited amounts of time for that. I think good friends are ones who call you out when you do bad things and sort of point out when you make mistakes and so on and so forth. So I think it is in that spirit that I've approached pretty much any writing that I do. And whenever I've had the opportunity to submit my writing for feedback. And to me, genuinely does not matter the status of the person who is giving that feedback, because to me, it's more a reflection. Somebody's feedback, whatever that feedback might be, good or bad, is a reflection of what they understood from your work, right? So if you're not able to convince them that what you've written actually makes sense, or if you were able to convince them that what you've written does make sense, then that's a reflection that's coming to you from somebody else's perspective as you're reading it, right? And then whatever work you end up putting out, you can't really control who gets to read it beyond the point. I mean, of course, there will be ways and means that you could to some degree, I guess, but you can't really do it at a large scale. So we have put up, to use your example, we have put up a blog post. Generally, that link, I put up that link somewhere on the internet, and anyone could come across it and send me feedback on it. I can't really do that person. So I think a lot of humility comes from that initial recognition that, look, this is just a part of the game, and you have to be into that. I think in the process of the book writing in particular, and I've done this even more recently because I have a second book in the works on design. The key to me was to be able to identify who would be able to give me good feedback on what parts of the book. I think that was the key point of challenge, because I think to a lot of people, you could give them like the whole manuscript and they would probably either not be able to give you good, meaningful feedback that would drive the book forward. But it would also perhaps put you in a place where you wouldn't be able to benefit as much because you respect that person's opinion, and you then would perhaps make changes to that thing that either won't necessarily or certain people sometimes just give you comments out of politeness and they don't really intend them and so on and so forth. So for me, a very important part of that process, and I took 2 weeks to do this, like 2 weeks just doing nothing about the manuscript, just focused on who's going to give me good feedback on this portion. And then what I started to do as far as colleagues, etc. was concerned, is that I started to make like a table. I have like this Excel sheet that I made about, okay, this person, this topic, this topic, and so on. This cute little thing that I was able to make, where I was able to identify people who have actually worked on cases in that area or who've done a lot of research in that area. And then I shared those bits with those people. So the entire thing, nobody managed to look at apart from my editors, obviously. But those individual bits, when I got feedback from colleagues and so on, they were given parts of the text based on their own competence. And then when they returned feedback, I noticed that it was almost entirely on point. So I lucked into that to some degree because I don't think that I had this grand idea of getting feedback in my mind when I started. But now that I've lucked into it, I think I'm going to continue using it until it runs out.
Got it. So I think I have one last question, and I think this podcast would not be complete without me asking that question. So this is around tennis because particularly I got to know about you by reading your blog on tennis, on different matches on Nadal versus Medvedev and all the other things. And being a tennis fan, I particularly adored your writing style. And so this is a question as a fan, like who is your favorite tennis player and why?
Okay. So I am actually more wedded to a play style than to an individual tennis player. That might sound like a bit of a hipster answer, but I swear it's true. So I started watching tennis in 1995 when I was 8 years old. And my two favorite tennis players to start with, or I started properly watching tennis in 1995. I have memories of watching tennis from even before that, well before that, in fact. But my two favorite tennis players at the start were Stephanie Graf and Stefan Edberg. Okay, and the fact that their names had similar sounding, like they had similar sounding names, was a big allure to me. And then unfortunately, I realized that I caught Stephanie in the middle of a lot of injuries in her career, and I caught Stefan Edberg right at the end of his career, actually, right at the end of his full professional career. And therefore, my immediate search for new heroes sort of built off of that template. And from Stefan Edberg in particular, as I speak about the men's side first, I looked far and wide to find basically a better version of Edberg to support, and my eyes first landed on Pete Sampras in around 1996. It's a strange time because I remember Pete Sampras, that was 96 was the one Wimbledon, because that used to be the tennis tournament that everybody used to watch back then. That was the one tournament, that was the one Wimbledon rather, 96 was the one that Sampras did not win. He lost to Richard Krajicek in the quarterfinals. And I remember it feeling like this giant tragedy because there were so many Sampras fans around me, and I was like, oh my God, how could this guy lose? And he was supposed to be unbeatable and so on. So I followed Sampras pretty much to the end of his career, and the end of his career overlapped with a little bit with the beginning of Roger Federer's career. And so that became like a natural sort of entry point, even though Federer was a very different kind of player. And on the women's side, I think I searched long and hard for a Stephanie replacement, and I could not find one. And therefore I gravitated towards what was generally the American style. And I found Lindsay Davenport, and I found Jennifer Capriati, and all those people who I found extremely entertaining to watch. And then from there, I think it sort of went in its own direction. And I've had a very healthy respect for women's tennis, which I think in several ways is a far harder sport to play than men's tennis, because the margin for error is so small. And to me, this would, I'm getting slightly off the track of who my favorite tennis players are. But I think this is, to my mind, is the principal reason why you could make a greatest ever case for Serena Williams, is simply that for her entire career, she's basically had no margin for error. Like, if you lose 1 second, right, I mean, there is genuinely no place to run, and the fact that she's been so remarkably successful while her game has been so deeply studied around the world by so many different people is one of those core cases why it's definitely one of the greatest. But yeah, I mean, from there, from the Federer departure point, I think I've gone in all different directions. I don't think that I can honestly say I have a favorite, but I think those memories from my formative years, especially Edberg and Sampras and so on, they're big favorites of mine to this day. In fact, I enjoy going back and watching a lot of old tennis matches and sort of So I've given a long-winded answer, but I think betrays a little bit of how interested I am in this sport. And in all sport in general, but I thought I should give you a little bit of reason as to why I picked it.
Definitely, and I would also urge the listeners to check out the articles Eashan has written around tennis, and I'll also leave a link in the description. I think thanks a lot, Ishan. This has been an amazing conversation, and I think this would provide a very good gateway for people, especially from a non-legal background, who might be interested to know more or study more about this topic, especially trademark law, because I think it sits very comfortably at the overlap of business management and law. So that is something that the audience would be interested in, and especially I particularly found the part where you talked about the process of writing and how you used to stay up at 2 and wake up at 6 particularly encouraging, because like you hear these stories from people and realize maybe like this is something possible. Like it's not just in my mind. If I work hard enough, maybe someday if someone else is interested in writing a book, they can pull it off as well. So thanks a lot. I'll also leave the link to purchase this book. It's available on Amazon and all other e-commerce platforms in the description, so people who are interested can check this out. Thanks a lot, Ishan, for your time. Hope you enjoyed talking to me.
I did indeed. Well, I'll say two things to conclude. One is that I'm not sure if this interview or this conversation has been a particularly good introduction to the subject matter, and I'd encourage everybody to check out the subject matter independent of what I said, because as we conclude, I think that old saying is coming to my mind about some people talk better than they write and others write better than they talk. I'm not sure which part of that divide I fall under. But I think the other thing to say, of course, is that because this is my first book, and I'm obviously, like I mentioned, I'm quite open to feedback and so on and so forth. I'm very happy for people who reach me via this medium, via this interview, are able to access it, to be able to reach me privately and ask for any kind of assistance or any kind of guidance on better understanding both the text and on trademark law in general. I'm very open to that. I always try and make sure, at least in the spirit of helping others, I try and make sure as much as I can that I give time to people who want to learn more about it, because I want more people to be as obsessed with the subject. And it's always a pleasure to talk to people who especially are getting into the subject and so on. So great to have this conversation, and I'm very happy to take this forward offline with whoever's had a chance to hear us chat for what has been God knows how long now. So I'm extremely glad that we had a chance to do this. Thanks a lot.
Thanks a lot, Ishan, and that's a wrap.